Everybody say, 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 how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. You're my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. You're my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya matinyana. Uya matinyana. Yeah. Uya matinyana. Oh, uya matinyana. Say, I call you Jireh, say. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. We are me ground cover. 1, 2, 3. I can breathe without you, sir. I can breathe without you.
Good morning, good afternoon, good evening to all our viewers and listeners, depending on your location. My name is Annie Akofiosowa, and I am your host for today. Welcome to another episode of the Community and the Law, which is brought to you by BWTV and BWF Solicitors, which is located on the 4th floor of Anna House, 214 to 218 Tottenham High Road, London, N15 4NP. So just to repeat our address, we're located on the 4th floor of Anna House, 214 to 218 Tottenham High Road, which is in London, N15 4NP. You can contact us on the following numbers. So 02084837340. We also have an office in Ghana, Accra. So if you live in Ghana and you need legal assistance, you're more than welcome to go to our Ghana office. And the number for that office, as you can see on screen, is 055 599 5959. So I repeat, it's 055 589 5959. So yes, welcome once again to another episode of the Community and the Law. BWF solicitors are open from Monday to Friday, 9 a.m. to 6 p.m. And we offer a range of services, legal services, just to help those in the community. So we do immigration law, we do family law, whether you need assistance with child arrangement, divorce, financial settlement, whatever it may be. We also do probate and wills.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello once again to our viewers and listeners, and welcome to those who have just joined us. We're just coming back from a short commercial break. Please ensure that when you join whilst you're watching, that you like the program, that you share it, and that you also leave a comment. So wherever you're watching, whether it's on Facebook, LinkedIn, YouTube, whatever platform it may be, please like and share the program. So at this stage, I would like to introduce our resource person, who is no other but lawyer Charles Asma. Hello, lawyer Charles.
Hello, Roy
Hello,
Annie.
how are you?
Very well. How are you?
Great, I'm fine. Thank you for asking.
Great.
Yeah.
So, viewers and listeners, today we are looking at another interesting aspect of our weekly dialogue. And today we zoom in on a very, very crucial matter. Of course, we have the nuggets. So, I will move you back to my host who introduced the nugget, and we have a look at the nugget before we zoom in on the wider conversation for this afternoon.
Thank you very much for that, lawyer Charles. So yes, we're going to have a look at a few things, starting off with a birthday. So it was Chelsea's birthday. Happy belated birthday, Chelsea. I hope you had a lovely day. I mean, here at BWF, you do play a very important role. We all feel very comfortable coming to you for assistance when needed. You are an important member, and we do appreciate you very much. So, from all of us here at BWF, we hope that you had a lovely birthday, and we pray God's best for you. All right, so here we have a client review. This is something that we encourage very much at BWF Solicitors. We always ask for clients to leave a review once we have completed their cases, just so that the word goes out there, that people are informed that BWF Solicitors is able to deliver and is able to deliver well. So as you can see, we have a review from L. Brown. Thank you, L. Brown, for your comments. L. Brown said, if you're looking for an excellent immigration solicitor, BWF Solicitors is the best. They are very effective, and I'm very happy with the service provided from start to end. Will definitely recommend to everyone. L. Brown, we're very grateful. I'm glad that whether it's your application or your appeal or whatever it may be, I'm glad that it went well and that BWF Solicitors was able to assist you. Lawyer Charles, would you like to speak at all in or comment on L. Brown's comment?
Yes, Al Brown, you are one of the many, many, many members of the community who have benefited from the knowledge, expertise, professionalism, and service that BWF Solicitors offers. And like Al Brown, I know many of you are able to join every day during our sessions and also phone in and dial in simply because you know BWF Solicitors is your go-to community law firm. And therefore, your next testimony or satisfaction rests with BWF. Call a friend to tell a friend that we are ready to support you with the knowledge, with the experience, and the expertise. And you will be the next to give this testimony.
I love that very much, Lawyer Charles. Yes, all our clients, please call a friend or tell a friend to tell a friend, and let's get the message out there. So, the next thing that we would move on to is the nuggets, which I'm just going to read. So, it says under Appendix EU to the immigration rules, a person's limited leave to enter or remain may be curtailed where the Secretary of State is satisfied that it is proportionate to curtail that leave where the person ceases to meet the requirements under which such leave was granted. And this is in line with Annex 3, paragraph A 3.4c of Appendix EU to the immigration rules. Lawyer Charles, would you be able to go into a bit more detail? We would be very grateful.
Of course, I can and I will. Yes, so viewers and listeners, so the nugget for this week is clear, and the key word is cease, and the expression there cease to be. So, where the person ceases to meet the requirement under which such leave was granted. Now, we look at Appendix EU, which deals with EU applications as family members of EU, be it spouse or parents or children. And in this case, Annex 3 of that particular paragraph, paragraph A3.4C of Appendix EU, is clear that once somebody has entered the UK under EU rules to join a family member and they cease to be a member of that family member or cease to be a family member of that EU national, then that person cannot hold on to that visa granted under that requirement. For example, you come in as a spouse, and if there is no more relationship, then the relationship is not subsisting. In this case, the visa can be taken or can be cancelled or literally taken away from you. What about parents? You cannot cease to be a parent, and therefore, parent can never be an area that this nugget will touch. What about children? Again, you cannot cease to be a child of somebody because it's by birth. The only thing that will break that relationship is death. And the only thing that will break relationship in terms of parent is also death. And so here you can see that if somebody is going to cease to be a family member or cease to meet the requirement, i.e., to be a family member, then it can only be a spouse. So the nugget is actually drawing attention that if you are a spouse of an EU national and upon joining that family member, you cease to be a spouse of that national or EU national, then your visa cannot remain. The question is, what does it mean to cease to be a family member? Ceasing to be could be separation. If there's divorce, of course it ceases to be, but there could be other reasons why you can continue to survive on that visa. But if it is separation, which means that the relationship is no longer subsisting by a factor other than death, then paragraph A3.4C of Annex 3 of Appendix UU will be invoked to the effect that your visa can be cancelled.
Thank you, Lawyer Charles. So, yeah, you've made that very clear that this nugget is mainly for spouses who cease to be family members of EU nationals. So, just a question: how can someone know, let's say, an EU family member's spouse? How can that person know that their leave has been curtailed?
So under the rules, if you look at this, it says may be curtailed. That means the Secretary of State will not take action to curtail until you have been informed, so that you can make a representation or you can explain why they should not. And therefore, under the minded to cancel policy, the Secretary of State has a duty to remind the individual that we have information suggesting that you have ceased to be a family member or you have ceased to meet the requirement under which you were last granted. Is there anything you want to explain or to say in your defense? If it is tenable or understandable, then the decision to cancel will be stopped. If it is not, then they will go ahead to cancel. So, how do you know you will be told? If you are not told, then that will be a procedural breach on the part of the Secretary of State.
All right, Lawyer Charles. Yes, thank you. So, if an individual is told that their leave is going to be cancelled or curtailed, and they receive a minded to letter, in that case, how can an individual, let's say they don't agree with the decision that the Secretary of State has made, what can they do? Do they, for example, have a right of appeal, or how does that work?
You mean if the Secretary of State goes ahead to cancel?
Yes, please.
Right? Because the person was given opportunity to explain and they chose not to offer any explanation, it then follows that they accept the intention to cancel. And if the visa is cancelled, then there's nothing else they can do. So they will be given opportunity to clarify, and that's the representation they have to make. And if the representation makes sense, then of course they will maintain the visa for the person. If not, then so the learning is that once you are given the opportunity to explain yourself, you have to make sure that you do so. Otherwise, you would have caused the decision to cancel to be effected.
Mm. All right, Lawyer Charles, that's very helpful. Thank you very much. So, viewers and listeners, we're just going to take a very short commercial break and we'll be back.
Based in London, we are a dynamic award winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome, viewers and listeners. So please again ensure that when you join the program that you like the program, that you share it with a friend, and that you leave a comment as well. So I'm just going to give you the telephone lines to call. Although the telephone lines are not opened yet, we'll open them at a later stage. But the number anyway to call is 0208 493 7345. So at this stage, I'd like to again call in Lawyer Charles so that we can delve into the main topic for today, which is actually quite exciting. So, yeah, as you can see on screen, the topic for today was visa applications based on domestic violence, types and implications, for the applicant. Yeah, so this is a very interesting topic because there are so many people, whether male or female, who deal with domestic violence. And so this is definitely a topic that is in season, which will help people within the community. So, Lawyer Charles.
Thank you very much, Loyani. And hello, viewers and listeners. Today, as the host rightly mentioned, we are looking at domestic violence applications, different types, and the implications for the applicant. The implications will be good and not so good. So we are looking at both aspects so that we are fully informed anytime we are making such applications. Now, the provisions are clear within Appendix Domestic Violence to the Immigration Rules, wherein an individual has entered the UK and the person entered to join a spouse, and the spouse has put the applicant or the dependent through some abusive um, behavior, or the person's behavior has affected that individual who is the dependent, and as a result, they have to find a way to sever relationship with that sponsor or the family member or the spouse in this case. Once they have severed that relationship, what happens to their leave to remain in the UK? And this is the position for this application. So that once you have severed relationship, the state takes up that responsibility, provided you meet the rules. So we look at what domestic violence is, a range of shapes. They will look at different types of application or who qualifies to make such applications. We look at the rules, and we look at the guidance for the caseworker, and will advise or will let you know as a potential applicant or somebody who has application already pending what happens if you are granted and what happens if you are not granted. And is it everybody who makes this application that will have the opportunity to get to indefinite leave to remain? So these are the range of things that we'll be covering in the conversation. So what is domestic violence? I will leave my host to take the conversation further whilst I come in with response.
Yes, Lawyer Charles. I mean, domestic violence is a very broad, I mean, if you look at the legal definition, there's a lot that goes into it. I think the main thing that comes to mind is just when someone is being physically abused. But of course, we know that it can be economic abuse, it can be blackmail, it can be threatening, all types of things. So would you be able to give us the definition of domestic abuse?
Thank you very much. So, abuse is any behavior that puts the other party into distress, leading to loss of life or loss of health. This happens within the home and is between spouses. Now, the behavior can be in the form of withholding financial support from that dependent or partner. And withholding that financial support simply means that if they are not working and they depend on you and you decide not to give them money to fend for themselves to meet essential living needs, that is financial abuse. Or they are working, but you control the money. So whatever comes in, you decide what the person can use the money for. That is financial abuse. So, financial abuse just two ways: the fact that you don't look after them, or the fact that whatever they bring in comes to you because you control everything and you decide how that must be spent. The other aspect is emotional, and here it could be insults, could be shouting on the person, causing the person to become apprehensive. So, if calling the person names, preventing the person from meeting friends, from associating with others, from allowing friends to visit, to the extent that you are even always poking your nose into the affairs of the person in terms of what they have on their phone or what they use their phone for and all those things. These are all things that can emotionally affect that dependent. And because the dependent depends on you, the sponsor, they cannot speak. In that, if they speak, they feel that they are going to upset you and you will not renew their visas for them. So that is the emotional aspect. And the emotional will then tie in with psychological abuse because it affects the person's ability to uh, um, think straight and to behave appropriately in terms of what they can do. And so, emotional abuse, psychological abuse, they go hand in hand because it has to do with what is happening within them. There is also physical abuse where you actually beat the person to the extent that there are marks on the body. That is physical. Either smacking or whatever you do, throwing objects at them, cutting them, bruises here and there. These are all physical. And with physical, of course, then there will be evidence of that physical abuse. And so these are the key areas that will cause the other party to fear for their lives to the extent that they will need support from external bodies.
All right, Lawyer Charles, thank you. So when we're talking about domestic abuse today or violence, we're talking about emotional abuse, economic abuse, psychological abuse, and physical abuse. Thank you for that. So, in terms of the sponsor, what type of leave does the sponsor need to have to begin with, Lawyer Charles?
So, what we're going to do is to look at the types of sponsors. We'll let producer show us the rule book, but suffice to summarize that we are looking at somebody who has sponsored the applicant to enter the UK on the basis of Appendix FM, and here Appendix FM partners. We're also looking at somebody who has sponsored to enter the UK on the basis of Appendix EU, so EU family members. And we're also looking at workers, somebody who has and sponsored a partner to enter the UK to join them as skilled workers. So these are different types or categories of domestic violence applications. As an Appendix FM partner, here we're looking at you have indefinite leave to remain, or you are a British citizen and your partner joined you. That's one. Or you are in the armed forces, your partner joined you. That is two. Or you are an EU national, your partner joined you. That's three. Or you are a skilled worker, your partner joined you. That's four. So these are four different categories or types that domestic violence applications can fall under. So we look at the rule book. Producer, please, back to the rule book. So if you go down, so we are looking at, so my host will take it from there. We are not going to go into the validity, but go down to eligibility. Eligibility, yes, we look at eligibility, then we'll go to relationship requirements. So eligibility. Um, yes, my host. So Annie, if
All
you
right.
can.
Yes. So entry requirements for the victim of domestic abuse route, VDA 3.1, where a person is outside the UK, they must apply for and obtain entry clearance on the victim of domestic abuse route before they arrive in the UK.
So
VDA 3.2, where a person is applying for entry clearance on the victim of domestic abuse route, they must, if appendix tuberculosis applies, provide a valid medical certificate confirming that they have undergone screening for active pulmonary tuberculosis and that this tuberculosis is not present in them.
okay, thank you. Yes. So what it means is that under this provision, it's not only for people who are already in the UK.
Mm.
If you are abroad, you can still apply. How does that happen? For example, you are living with your partner. Your partner tells you that, you know what, let's go on holiday. We are going back to our home country. You go thinking that it's a family holiday. By the time you realize your partner is back in the UK and you are stuck in that home country and potentially has seized certain things and you cannot even come, or tells you that you cannot come back, You dare not. You stay there. So that is abandonment. And because you've been abandoned there by your sponsor and there is threat that you cannot come back, then you who have, if you can prove that you have been a victim of domestic violence, then you can apply to enter the UK, not as a sponsor of this person, but under the provisions available within available for such people of like you. So let's go down to relationship.
Relationship requirements for a victim of domestic abuse. VDA 4.1. The applicant must have or have been last granted permission as one of the following: A, a person under Appendix FM,
Good.
except for permission as a fiance.
Hold on, hold on for us. So with this one, just mention the key parts. If it
Okay,
is FM, so appendix FM, then the next one,
okay,
durable partner in that order, not necessarily reading to the end.
okay.
So, ladies and gentlemen, and viewers and listeners, we are looking at who qualifies to make the application. The person who qualifies is the one who has last been granted. So your last leave or your current leave that you wish to switch to the skill to the domestic violence route should have been granted as somebody under one of the following. So the A is appendix FM partner. So your sponsor had indefinite or your sponsor was a British citizen and you joined them. So that's A. B, please continue.
AA, a
Sorry, AA,
spouse,
yeah.
civil partner, or durable partner under Appendix EU with limited leave to enter or remain.
Okay. So here we are looking at somebody who has been in a relationship for 2 years and the sponsor was or is an EU national with pre-settled status. In this case, the person came or remained with the spouse as a durable partner, not married partner. So that's the difference. Durable partner, 2 years of relationship before the visa was granted, or partner, which is partner with marriage, which is marriage certificate evidence.
All right. B, a partner under Appendix FM, Part 11, or Appendix Family Reunion Protection of a person with permission as a refugee.
Okay, so these are ones for refugees. So somebody might have been a refugee. The partner was also granted or joined on that basis, and they are going through abusive relationship. Then they qualify because they were last granted under that.
C, a partner of a person present and settled in the UK under paragraph 285 or 295E of Part 8.
Okay, right. Yes. So again, this is one of the old categories where somebody was granted indefinite leave to remain. But the moment we see that there is settled status for that person or the person has indefinite leave to remain, then the partner uh, is a dependent of somebody who is present and settled, similar to Appendix FM, just that is the old type. And so it is not Appendix FM per se, but it is still similar to that. We'll go to D.
A victim of domestic abuse under Appendix FM.
All right, so all these ones, we see that it says for D, a victim of domestic abuse under Appendix FM or a partner under armed forces. And it goes on to say that of any below. So a person who is British is similar to all the points we have already raised. So we move on to F.
F, a leave outside the rules granted under the Migrant Victims of Domestic Abuse concession.
So here we are looking at if you are going to apply under this category, especially those proceeding to indefinite leave to remain, if they qualify, they should have first been granted the 3 months concession as a migrant victim of domestic abuse concession, which is formally called destitution, domestic violence concession. So, in other words, you should have been granted 3 months before you can progress to the next level if you qualify.
VDA 4.2. The relationship between the applicant and their partner must have broken down permanently as a result of domestic abuse.
Good. So here the relationship is a factor, and we look at whether the relationship is still subsisting or not. If it is not subsisting, then we say that it potentially have broken down permanently. Not necessarily that they are divorced, but that is broken down permanently. So they are separated, and there's no intention to come back because of domestic violence. And if it is indeed as a result of domestic violence, then the party is unable to return to that relationship. And so it will be a reason for making such application.
VDA 4.3. If the applicant is applying from outside the UK, they must have been abandoned outside the UK.
So if you are so that is for those applying from abroad, you have to prove that you've been abandoned. And that's the example we gave that you went on holiday with your spouse. By the time you realize your spouse has returned without informing you, giving you reasons or excuses. So we went on holiday. Why have you abandoned me? And it will click that, oh, right. So this is why. But you've been a victim. If you can prove that you've been abandoned there, what it means that being abandoned means that the person actually made you go there and there's no reason to come back, or the person went there with you and didn't return with you, and there's no reason possibility of letting you come back. That is the abandonment criterion. Right. So with this in mind, we know that under appendix domestic violence, you have to have certain visa already issued before. Now, the new category that we are adding is for those who are under work route, could be skilled workers or any other work route. And that is an exception to the general rule. You can see that the ones we've looked through so far did not mention work, but there's work aspect when we look at the concession guidance. So we are looking at the concession guidance, and after that, we look at the implications. So, producer, if you can show us the concession guidance for the caseworkers. Right. So, migrant victims of domestic abuse concession, and this was issued on 25th of February 2025. So fresh. What does it say? We look at the content. If we look at eligibility, so eligibility, we have EU. So EU people who are subjected to dependents who are subjected to domestic violence can benefit under this concession. And we're also looking at work route. Work route could be skilled workers. They also benefit from this. Children, of course, also benefit if the children are applying with the dependent parent. Now, the application process, we are not going to go into the application process per se, but the key thing is deciding an application, whether to grant or not to grant. In deciding the application, please, let's look at what the caseworker ought to do. So, deciding application per year. So, please, Loyani, if you can take us through that.
Yes, deciding an application. This page tells you about deciding an application for permission to stay under the Migrant Victim of Domestic Abuse concession, granting permission to stay. Those who meet the criteria of the MVDAC must be granted leave outside of the rules for 3 months on conditions permitting employment with no prohibition on recourse to public funds. This will vary in any permission currently held by the applicant.
Right. So the first thing we have to remember is that the moment you have sought to rescue yourself under this concession or provision, you are abandoning the leave or the visa you are on to a different visa which has no definition within the rules. And that is why it's called leave outside the rules, because you are moving from Appendix FM partner or work partner or any of the categories we've mentioned under 4.2, and you are now coming to a separately new order which has no definition. What it means is you are going to be granted amnesty, and that amnesty will have risks. And it says that even though you are going to be granted amnesty, which is live outside the rules, you have opportunity to work. You have opportunity to seek public fund. So it will come with recourse to public fund, and you'll be given for 3 months, and that will override your current leave. The moment your current leave has been overridden by this 3 months concession grant, you cannot say that I'm on 2.5 years or 5 years anymore. Now you are on 3 years, 3 months. The question is, what do you do to ensure that you're able to progress the 3 months to something else? If you qualify, you progress the 3 months to indefinite leave to remain. If you don't qualify, then you only stay with the 3 months. And after the 3 months, you cannot go back and say that, oh, my partner or my spouse is now okay, we've come back together, and so give back my original leave to remain. It doesn't work like that. And that's why it says that conditions permit. This will vary any permission you held before you attempted this application. Now, in terms of settlement, partner under FM, yes, they qualify for settlement. Partner under EU, they qualify for settlement. Partner under armed forces, they qualify for settlement. Partner under refugee status, they qualify for settlement. Partner under Part 8, Appendix FM, they qualify for settlement. How about partner under work? Partner under work does not qualify for settlement. And so please, here, listeners, viewers, what we are saying is that if, for example, you're a skilled worker and you apply for a 3 month concession because you claim that you are going through domestic abuse or violence, and before the final decision is made, they have to give you protection, which is the 3 months. As a skilled worker, that 3 months cannot extend to indefinite leave to remain. So let's bear in mind um, before making such application, make sure that you are aware that the 3 months protection will end once the 3 months is up, and after that, that is it. Unless there is good reason to extend it for you. But workers, those on the work route, do not qualify for automatic indefinite leave to remain. And again, is the indefinite leave to remain automatic at all? No, you still have to meet the criteria. So let's look at the application that was made before the current visa expired and the application that was made after the current visa has expired. The starting point is that this type of application has no expiry date. So that if somebody said that I went through domestic violence 3 years ago or 1 year ago or 6 months ago, but my visa expired a long time ago before I realized that I was going through this, yes, it can still make the application. So it doesn't matter whether it's expired or not. So let's bear in mind that the rules under 39E, 14 days or not applying while the visa is still valid, are relaxed under domestic violence. So whether the visa is expired or it is not expired, you can still apply under domestic violence if you qualify. What if you have applied for the 3 months concession before your current visa expired? And let's call this current visa the abused visa. The abuse visa is the one you hold, and because of that, you want to exchange it for something else. Now, if the abuse visa was still valid once you are making the application for the 3 months concession, then you are protected under Section 3C. Your work will remain and your rights will remain. The moment you are granted the 3 months, you then continue with the 3 months. What if your visa expired before making this 3 months concession application, Section 3C will not apply to you. And so if you are working and the employer says that, you know what, if you have applied for 3 months, wait for the decision to come, you have to stop because your visa expired before you attempted the application for the 3 months concession. So let's note the difference. 3C applies if the concession application was made whilst your current visa was still valid. 3C will not apply if the concession application was made whilst your current visa, had already expired. So that is the difference.
Oh, yeah, Charles, that's very educative. Thank you. So, in terms of the application process, if someone wants to apply for the concession, how would they go about it? Can they just find the form online, for example? What is the name of the form? If you could shed some light on that, please, to help those in the community.
Thank you very much. Uh, and also, whilst we are here, before we move into the application, because we are looking at implications, so let's discuss the implications before we look at, okay, I'm now going to make an application. I understand what the implications are. So, implications for the applicant. Having understood all the nitty gritties, the implications are one, the application will be granted, but it will not lead to indefinite. Two, the application will be granted and it will lead to indefinite. Or three, the application will not be granted at all and therefore you will be left with nothing. So, do you have to meet certain criteria for it to be granted? Yes. The key word is the abuse you are claiming. So you have to provide evidence. How has this affected you and your general well being? What help have you sought? Where is the evidence? And all these things. Once the evidence is understandable or convincing, a decision will be made to support you in terms of giving you that 3 months concession. The 3 month concession, most of the time, people get it, including skilled workers, because it's emergency concession to make you survive so that you don't have to be worried about enduring the abuse and at the same time being worried about your leave. But having been granted the 3 months, is it automatic that it will lead to something that you are looking to have? No. And so domestic violence application can be refused. And once you are refused, that is the end. There's no appeal right. Let's bear in mind. There's no right of appeal. The only thing you can do is to go for judicial review, but not an appeal. Why is there not appeal? Because this is not a right. It's just a consideration of your situation. And so you can't say that, why have you refused me? So I'm going to appeal. The only thing is that, why have you refused me without following the rules? And so I'm seeking judicial review or interpretation of your action. So let's bear in mind, under this application, no right of appeal, only judicial review. Under this of application, you can get it or you can not get it. If you don't get it, that is it for you. If you get it, it may be that you get it for only 3 months and you cannot make progress to indefinite leave to remain. But we know that workers or skilled workers, dependent on skilled workers, once they put in this application, they cannot progress to indefinite leave to remain. Somebody will say, then what's the point making the application as a victim of domestic violence, skilled worker dependent? Because you want to put in the application so that you have the protection, the short-term protection. And because it's an emergency situation, the application will have to be made. And that's the only reason. And it's for only 3 months. So, in terms of the application, we have a form that ought to be completed. So, the Migrant Victims of Domestic Abuse Concession form. The form will detail specific things that you need to complete. Once you've completed the form, you add your evidence and you send it to the case working team, either by posting it or by emailing it. It will be processed. If they think your evidence is clear and your claim makes sense, you'll be granted 3 months. Now, how do you prove? We said that your case is that you are going through either financial abuse, psychological abuse, of course, financial and economic, psychological abuse, emotional abuse, or physical abuse. Then you have to provide the evidence to support that. If there are agencies involved, GP, then you have to get something from that or in any other agency that is involved. If you are receiving treatment, you have to provide the treatment plan or evidence, all that, and report from those agencies supporting you. How have you coped up to this point whilst your sponsor decided not to assist you to provide your living needs? Were you being supported by a charity organization, including churches and mosques, or you are getting support from friends and family? I mean, if I say family, there could be other family members or generally friends. How have you been surviving? So you have to provide evidence. And once all these are put together with the application form and your identity document, you send it for processing. And the aim is to be granted 3 months. After 3 months, we look at the next stage. Now, so the application has been made. You've been granted 3 months. Congratulations. Is that the end? Within 3 months, you have to apply. That is, if you qualify. So if you qualify, the letter will say that within 3 months, you have to apply for indefinite leave to remain. And we know that skilled workers cannot apply for indefinite leave to remain unless very, 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 very limited circumstances. Very rare, very, very rare. And so skilled workers do not have opportunity to progress to indefinite. So those who have opportunity to progress to indefinite are the ones we have already outlined. Appendix FM, Appendix EU, Appendix Armed Forces, Appendix Refugee Status Programs, and also Part 8 of the Immigration Rules. All those ones will qualify for indefinite, the next stage. Now, you are applying for indefinite the next stage. You have to provide evidence that it is even detailed and more than you provided before when you were applying for the 3 months concession. And so, during the 3 months concession window, you didn't have much evidence, but because of emergency, they had to listen. And that you are going to apply for indefinite, you cannot rely on those limited evidence. So your evidence now should be detailed. Your own statement of account, that of friends and family, if there are people to support that, and also from agencies or third-party organizations who have been providing support, your GP and others. All these are very, very important. And the support you've been on, medications, counseling support, if you went through mental health, all those ones will have to be added. And the next stage will be providing evidence of what was actually happening in the home. You said financial abuse. How? You said physical abuse. How? You said emotional abuse. How? Somebody will ask, but if it's emotional abuse, how do I provide evidence? But you have to provide an account of that. There are people who are able to provide because it's physical abuse. Some people with represented in recent times. Some go through physical abuse to the extent that there are marks on their body, eyes, bruises on the eye, and other parts of the body. All these are examples, and they take photos of them to support their claim. If it is financial, you got to still demonstrate that. So the photographic evidence could be relevant to your case if you have them. So your own account will then be corroborated by the third party agency account, and then the caseworker will make a decision on that basis. Now, because this is indefinite leave to remain, you have to pay the fee. And the fee currently is £3,029. It used to be £2,885. So it's gone up. You have to pay, or you apply for a fee waiver, going through the process for applying for fee waiver, showing you cannot afford, or affording means it will affect your children. Now, those with children, this will cover their children as well. So when you are making the application, you include the children who are under the same visa as you. And once you qualify or meet the criteria for a fee waiver, the fee will be waived for you and the children consent. And then you apply, you go through the process, making the application, paying the fee with the fee waiver code, or paying the fee with your bank card if you don't have a fee waiver code. Then you book appointment for your biometric. You go for your appointment, provide the passport copy, your passport, and also your documentary evidence, and wait for a decision to come. And the form to use is set DV. Set DV.
Yeah, thank you, Lawyer Charles. So we know that, of course, one of the validity requirements, as you rightly said, is to provide your passport copy or some type of identity document as part of the application. So what happens if, let's say, the person who has been abused doesn't have their passport because, let's say, their partner or ex-partner has taken it from them? Let's say their partner has told them that I'm the person who gave you the paper and so I'm taking it away from you. What can that person do in that circumstance?
Good. So in this case, they have to include in a cover letter note to explain that I understand my application will not be valid if I do not provide my original passport. However, my original passport is held by my sponsor, which is part of the large scheme abuse I was enduring. And so I do not have it. It wasn't a bother to me because it was more about my life than the passport. I have a copy I have added. However, I don't have the original. Then they will make a decision on that.
All right, Lawyer Charles, that's helpful. So when it comes to relying on letters of support, I know that you said that the victim themselves can write like a witness statement just to jot down what they have experienced. Let's say if it was physical abuse, the type of abuse that they endured. Would the Home Office place a lot of value, if I may say, on that type of document? Because of course, I mean, if someone may want to have indefinite leave to remain, they might just, put anything down. So would the Home Office actually rely on that type of evidence?
So we have what we call self-serving evidence. Self-serving evidence will be evidence yourself or evidence from third parties. But in this case, the third party's evidence will point toward the specific abuse you claim to have endured. And that will be corroborated by a verifiable agency report or account. And so you have to put together a chronology of events, and that will be corroborated by third party verifiable records or report as well. So yours is very important.
Thank you, Lawyer Charles. Another question. I believe that when it comes to submitting the actual application, as part of the document checklist, the Home Office expects evidence showing that, let's say, Party A and Party B were living together whilst they were married. But of course, we know that not all partners live together. That might be because of work. So one might live in Reading, the other one might live in Slough. In that case, if they're not able to provide evidence that they were living together at some point during their marriage, would that have a negative impact on the outcome of the application?
No, because it's an emergency protection for the individual. Whether you are living with a person or not is prima facie evidence. There's a Latin phrase which says that res ipsa licito, which means that the facts speak for itself or themselves. And so, if the fact is that the person has gone through abuse, and whilst they were living with their partner, then it's obvious that they were living together. So they don't have to provide evidence of living together.
All right, Lawyer Charles, thank you. So please, if you could ride on with the topic, we're all ears.
All right, yes, so we'll continue. Yes, so ladies and gentlemen, viewers and listeners, in a nutshell, the domestic violence program or route is clear, and you have to know that this is for you before you attempt. Because once you get on it and you don't get what you are applying or seeking, you have lost everything. So let's bear in mind.
Right. Thank you, Lawyer Charles. So, with the concession, you went into a lot of detail, very helpful. We know that the victim, would receive 3 months in which they would be able to claim benefits if need be, and they would have 3 months. Their leave would be now separate from their partner. All of that is all good. How long would it take for the concession to be granted? So, we know, like with human rights claims, it normally takes, like, the processing time is at least 6 months. With the concession, is there any processing time at all?
What I have experienced from what I've been um, dealing with for um, clients is that there's no one fix all date, just like any other application. Some are able to get it within 2 weeks, some within 4 weeks. There's one application went within a week, the person got a decision for the concession. The other person took about a month. But by and large, you just have to make sure they have a solid evidence and you put in the application. But because it's an emergency request, they try to work on it um, as fast as possible. We cannot place time value on it. However, we say that once you put in and you meet the rules, because they will check. The only reason why it will take longer is if they are carrying out some checks to verify what you are saying. In this case, it may be back and forth. Otherwise, it shouldn't take so long.
All right, that's very helpful. So, just for the sake of clarity, maybe some viewers have just joined us. So, of course, this application would be for indefinite leave to remain, and we know that normally, of course, when it comes to indefinite leave to remain, the applicant would need to sit the Life in the UK test. They would need to meet the English language requirement, either by having a degree that was taught in English, and ECTIS has confirmed that it's equivalent to the required level, and they have to sit the Life in the UK test. So, just for the sake of clarity, Lawyer Charles, when it comes to this type of application based on domestic violence, would the applicant have to sit the Life in the UK test, for example?
No. So in this case, there's no English language requirement. And it's all stemming from the fact that it's an emergency support. So all the criteria that ordinarily would have to be followed are cut out for this program or this route. So no English language requirement whatsoever. So much as the person needed to prove English language before joining the family member, for example, under Appendix FM, when the person is applying under Set DV, they do not have to show English language and they do not also have to show the life in the UK.
All right. So there you heard it, viewers and listeners. When it comes to submitting an application under Set DV, you do not have to prove the English language requirement, that you've met the English language requirement, and you do not have to sit the Life in the UK test, which is, of course, good news. So at this point in time, we're just going to take a very short break and we'll be back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back to our viewers and listeners. We have dealt with the main topic, which was very useful. So thank you, Lawyer Charles. At this point, we are going to go through the nuggets for this week, and I'm just going to read it once more. So it says, under Appendix EU to the immigration rules, a person's limited leave to enter or remain may be curtailed where the Secretary of State is satisfied that it is proportionate to curtail that leave where the person ceases to meet the requirements under which such leave was granted. And this is under Annex 3, paragraph A 3.4c of Appendix EU to the immigration rules. All right, so here we have the test your knowledge. It says Agnes and Jude married in 2020. On the basis of Jude's status as an EU national resident in the UK and her marriage to Jude, Agnes was granted a 6-month visa to join Jude in 2021. So please note the dates. Upon arrival in the UK, she was granted a 5-year pre-settled status. In September 2024, Agnes moved out of the family home to save her life due to domestic violence. So that's what we dealt with today. In December 2024, she received a letter from the Home Office that her visa may be cancelled in 3 months because she has ceased to be a family member of Jude. So what should Agnes do? Number one, as Agnes left Jude, she can not do anything about the notice to cancel her pre-settled status. 2, Agnes should make a fresh application based on her retained right as a spouse of Jude. 3, Agnes should respond to the notice citing domestic violence. Or 4, Agnes should make a fresh application under a different visa category to avoid becoming an overstayer. So those are the options. So please, if you could, again, just go through the test your knowledge, and if you could put your answer, what you think the answer to the test your knowledge is, in the comment section. So is it one, option two, option three, or option four? So please put your comments in the comment section, or you can also write your answer to the questions on using the WhatsApp line. So the WhatsApp number is 0795042270.
Okay, so so I think at this point, what we also possibly going to do is, I'm sure viewers and listeners will have questions they've sent in or questions they want to ring and ask. So potentially, we can make this time for them. So I'll give you back the.
Okay. All right, no problem, Lawyer Charles. So we do have a question on WhatsApp. So just a second. So I'm going to play the audio first. Lawyer Charles, can you hear the audio, please?
Yes, I
All
can.
right.
On council, but not for immigration rules. But for this marriage, and almost separate by divorce will go through. And no Bema for a quack. Tony Bema from Cover on the biological feather, and what the Bema in their quarters or council. And a new Kuno now along crater, so I won't say or the biological father in their quarters in the both. Tamam is a new swan English now. But on an legal implication, it is as a NT. Or more find I say or the biological father, Constable Papa no worry no and part to BBC and part to my boy the implication in the also with us.
Okay, right. So what the message is mainly is that this individual who is seeking um, advice or opinion from us is married. She got pregnant for another man and gave birth to this man. She and this man went to register the child, and so the birth certificate bears the name of the man who made her pregnant. So there are two men here. Let's call the first man the legal man. That is the marriage, the married, so the man who is in the marriage. And let's call the second man the biological man, the one who made the lady pregnant and had child with. Now, the legal man is called a legal man for a reason, because as long as the baby was born whilst the marriage had not been dissolved, the father of the child is this legal man, the one the lady is married to. Whether they were separated or this, or whether she cheated or whatever it is, the father of the child is the one who is in the marriage. The biological man has literally um, registered a child and his name is there, but the legal man can, of course, go to court and say, I'm supposed to be the man, the father of this child. The implication, we don't know what the child has because we're not told. But if the child status is based on the legal man's status, the one, not the biological man's status, the one who made the woman pregnant, then technically the child shouldn't have been given that status because the father is the one married to the mother of this child and vice versa. So we are, it's not clear to us what the reason for this argument or this confusion is all about. What the reason is, we don't really know. But if the reason is that the lady wants to um, apply for the one who made this person pregnant. For example, if the man who is in the marriage it was British or has had indefinite, and so the child had indefinite. And but even that, I don't know why. I don't see why the birth certificate bearing another man or another father will be used to acquire citizenship for the child. But when applying for the passport for the child or to register the child, it will be that we have to know who the father is. But it's also possible because we don't know the lady's status. So if the lady is the one who had the indefinite leave to remain or British citizenship, then obviously the child will take after the lady. Then these two men might be fighting for right to this child. And the right to the child, the one that has the primary right will be the one that is married to the child's mother at the time of the child's birth. It becomes so contentious, then they have to go to the family court to resolve the matter.
All right, thank you, Lawyer Charles. So we have a few questions. Yes, but the telephone lines have now been opened, so you can call. The number to call is 0208 493 7345. I repeat, it's 0208 493 7345. So you can call and ask Lawyer Charles your questions, and he'll be more than happy to answer them. All right, so moving on to the questions, we have a question from Irene, and she says, "Please, lawyer, my passport is with the border force, and I want to go to Ghana. How long is he going to take? How long is it going to take? I want to go back to Ghana."
Obviously, if your passport is not in your hand, you cannot travel. The only way you can, if you don't have your passport, is going to your embassy, the Ghana embassy in the UK, letting them know that you don't have a passport for this reason, and you need to travel to attend to an emergency. So you need a travel certificate. So with a travel certificate, you can travel to your home country. However, when returning, you must have your passport in your hand to be able to return to the UK. You haven't told us why the passport is with the border force. If the passport is with the border force for a reason, to the effect that they wanted to cancel your leave, and so they've seized your passport. Because there will be a reason for seizing your passport. You haven't told us. And so if you decide to travel because you have to travel, then you may jeopardize your chance of coming back if the matter with the border force is not resolved. So don't focus on the passport. Focus on why the passport was seized and whether it's been resolved or not.
All right. So we have another question from Kojo. He says, "Please, do case workers really read cover letters for visit visa applications, or do they base it on what is included in the application form? Please, if you submit income from your business, do you need tax documents for visit visas?"
Right. So Kojo's question are in threefold.
Hmm.
First part, is cover letter compulsory for visitors visa application? Cover letter is not compulsory. That is why it's called covering letter. What does it cover? It covers information that you have not already included in the application form. So you tell the caseworker that see the cover letter. And once you tell them to see the cover letter, you are signposting something relevant to them. And so then it makes it a duty for the caseworker to see or check the cover letter. So you have to let them know that check this information in the cover letter. But if you haven't said anything pointing to the cover letter, then they can ignore the cover letter. But if you say something on the application form pointing to the cover letter, then they must check the cover letter to know what is it that you wanted to say on the form. But because of space, you had to put together a separate letter. So that is that bit. Now, if you put everything that you want to say on the application form using the spaces available and the additional information box, then cover letter is not a big deal. Because cover letter is not compulsory, and so caseworker will read if you want them to read. So that is the answer to the cover letter. The most important form is the application form. And that is why it's important that you take your time to fill that form. The next part is, do I have to provide evidence of work if I'm self-employed? Yes, you have. Okay, so I think the second one is, do they base only on the application form? I think we've answered that. Application form is the master form, so make sure you fill it in detail and include everything. If you cannot include everything there, then you can add a cover letter and refer to the cover letter. The third one is, do I have to show that I'm self-employed? Of course, you have to if you want to rely on your self-employment business income or records or documents. In this case, you are saying you are self-employed and you are running a business. If you are running a business, then you must comply with rules within the country for self-employed people or for business owners. So you have to show tax, you have to show registration, you have to show audited accounts. So you have to go through the regulatory processes to make sure that the business is following the process as well. So you cannot just say, I am self-employed, I run a boutique, I'm making so much money every month, and so I will go and come back. And yet you have no evidence to show that this is a registered business and the business is following tax procedures or registration or annual return compliance process. So if it is Ghana, for example, you have to show that you have tax record from the GRA, which is the Revenue Authority. And also, you must show that the business is registered as enterprise or registered as a limited liability, private limited liability company with the Registrar General's department. Depending on whichever country you are applying from, there will be process for businesses. And so you have to show that the business is operating legitimately.
Yes, there you have it, Kojo. I mean, Lawyer Charles has answered your question. We have another question on WhatsApp, which I'm just going to read. It says, good evening, Uriku and Lawyer Charles. I am an EU national with settled status. Can I get married to someone in the UK who hasn't got any status at all in order for her to acquire limited leave to remain? That's the first part of the question.
Well, if the reason for marrying this person is to acquire limited leave to remain, as you have pointed out, then the answer is no, because the rules do not allow people to marry just to get a visa. So, unfortunately, the answer would be no. But if the reason is to have a family life and to permanently remain together until death do you part, or until there is reason to go your separate ways, then in that case, the intention is clear, and the intention is love, procreation, and marriage life. And on that basis, you have to show that there is relationship, be it 2 years in a relationship or marriage. However, you have told us that your spouse is an overstayer. And if the person is an overstayer, you qualify as a qualifying partner because you are an EU national with 5 years pre-settled. But your partner, even though you are married and you are living your marriage life together, he is an overstayer. So you cannot sponsor him under Appendix FM rules because as an overstayer, he cannot apply to remain in the UK under your sponsorship. So we look at the case of BAT versus the Secretary of State. And this is a 2025 case, which says that if the person is an overstayer and they are applying to remain with their partner, they must be refused unless they have a good reason to show that relocating to their country from the UK will affect their life if they were to be relocated or they were to travel abroad to make the application from there. Or if they are to travel abroad to make the application from there, it will affect the life and survival of their partner who has 5 years pre-settled as a EU national. And so here we are looking at whether going to your country to apply from there will bring untold hardship for you and your partner, and or there is life-threatening reason why you should remain in the UK and apply from the UK. Otherwise, the application will be refused.
All right. So the second part of this person's question is whether he can, as an EU national, whether he can bring his partner from outside of the UK into the UK, and they would like to know what the requirements are.
Did the person tell us what the relationship to this family member is? Is it a partner? Is it a partner? Bring their partner or bring family member.
He said bring the person from Ghana, but I'm assuming he means their partner, his partner.
All right. If partner, yes. Now the difference between bringing a partner from abroad and in the UK, if they're already in the UK, is that if they're in the UK and they don't have a visa, they cannot apply to remain with you. If they are abroad and they have a visa, if they are abroad and they want to join you, then they can apply. You are the sponsor. You have to have the EU national stay. You must be a EU national. You must have the pre-settled. But again, we look at the other aspect when the relationship took place, because under the programs you cannot also apply if the relationship took place after 2020. So if the person became a family member after 2020 and the person is not a EU national, then the person must have indefinite. If the person is an EU national, then the person can have the 5 years as reason for bringing their family member. So it's a whole range of analysis to confirm that yes, they qualify to do so. But from what the person has told us, they have they hold EU nationality, they have 5 years in the UK, so they qualify for their partner to join them. But the partner relationship element must be met, i.e., 2 years relationship, or they have married and they have subsisting relationship. Did the person say what document will be required?
Yes, please. What the
Proof
requirements
that
are.
prove that the person is a family member. You are married or you've been in a relationship for 2 years. Prove that this relationship has been continuing and it continues to up to this point, and that it will continue even after the visa is granted. And that will cover a whole range of information. And so we will not be able to give you everything on this platform, as other than just telling you that show relationship, show that you're a EU national, show that the person has done tuberculosis test, um, again, show that the person has done the English language test, because after 2020, they cannot apply and they, oh, so this person is EU national, so they can,
Yes.
but if the relationship is after 2020, then of course they cannot apply under EU. Now, in terms of other factors such as application fee and all that, they have to pay the application fee because the application will not be free under EU rules. But the main thing is that they should have met in person. So if they have not already met, then on what basis did they meet to be able to go into that relationship? Meeting on Facebook, meeting on WhatsApp, meeting through friends. If you have not done it face to face in person, then you cannot meet the relationship test.
All right. So, yes, if you want or have further questions, then please call the office and book an appointment so that we can go into a lot more detail. Thank you, Lawyer Charles. So, I have someone on the line. Hello.
Hello, good evening,
Yes.
Maya.
Good evening. Please, where are you calling from?
I'm calling from Essex, please, in the UK.
Nice, nice. So, please, your question.
Yeah, do you want me to speak in pure English?
Whichever you prefer. Whichever you prefer.
Okay, so basically, I'm just calling on behalf of my father. So, 59-year-old man, and he has a business enterprise in Ghana, which includes farmland and a shop. So, what he does is that he earns a proceed into his savings account from the business account. It's a registered business which was registered on 3rd June, but every 2 weeks he's earning about 2,000 pounds, 2,000 cities. So the month is like 4,000 20,000 cities into savings account. So now the question is that when you're filling in application for business, it asks you about whether you are employed, you're a pensioner, self-employed or not. So in this situation, because the business was just opened this month and he hasn't done the thing because he's done yearly, so in the application form, should he put that he's not employed, but he receives allowance only, or he should put that he's employed? And if you put that he's employed, how is he going to get employer letter, pay slip, and those tax issues? So it's a question that I want to get clarity on that, so that he can make a successful application, please.
Thank you. Lawyer Charles, did you hear him?
Okay, right. Is this person still there?
Yes.
Okay, director,
Yeah.
are you bringing your father to the UK for visit?
Yes. Yes.
And this man is, what did you say, 89 years old?
No. 59. 59.
69.
59. Yeah.
59. Okay,
Yes.
right. Now, you know your father better than I do. Is your father employed or a pensioner?
Now he's 59. He owns a business which was just
No,
registered in
hold
this
on,
month.
hold it there for me. Hold it there. Remember, the question was for him to select one category, right? Whether employed or self-employed and blah blah blah, isn't it?
Please, yeah, yeah.
Yeah, but that one, reading the various categories, knowing your father, you know what you select, don't you?
I will, but the only issue is that I would have selected physically the business account pays like
No, no. What I'm saying, no. What I'm saying is, so what would you have selected?
I would have selected, but because he's been receiving money from the business account.
No, no. What are the categories? Employed, self-employed,
But
or pensioner, isn't it? Three.
yes, yes, please, yes, please.
Which one? Which one fits your dad's situation, circumstance?
Self-employed,
So if it is self-employed, then you don't need us to tell you that. Are you with me?
please.
Then so that's the point. You must know what your father's circumstances. Then the question will be, how do I show or how does he prove self-employment? Isn't it?
Please, yes, please, yeah.
But that question has been answered before your question. Somebody asked the same thing. That visitors visa application, what would the person show? Should they show their tax and business record if they are self-employed? Did you hear that one?
Was following it, but the only issue is that business was registered this month, and the tax people were saying that it needs to be done yearly, so he wouldn't get that tax record for that. But it's registered though.
But business was registered this month.
Please, yes, but it's growing well, yeah.
Yeah, which is fine. But growing well, I don't think the growth will be so huge within 30 days.
Yes.
Yeah. So the question is, the business has just been registered. I don't think he registered the business with a view to apply for this, to make this application. And so, I mean, he can, because the business processes are not complete. He doesn't have evidence and all that. So you may declare that he's a pensioner, because what he's doing is just subsistence living activity. 2,000 Ghana is equivalent to how much in pounds? Less than
About
less than 100
yeah.
pounds.
Mm.
Yeah, less than 100 pounds. So that's not business. That is call it subsistence business activity. Whatever, is he selling or is into farms?
Okay.
What does he do?
It's a shop, provision shop, and a process from a farmland.
Okay, so he's selling. Okay, all right. So to be honestly, 2,000 Ghana is not a big deal. Uh, so even if he's self-employed, he can't say that he's going to rely on that money for for his visitor's visa application, because they will tell him that, well, you are making 2,000 Ghana a month. And so what shows that given opportunity to come to the UK, you go back. So everything should center around you. You are bringing your dad to visit the family and you are sponsoring everything. Your dad is a pensioner. Your dad does subsistence living, work for a living and to be able to keep fit. But because of that business venture that he's just started, he will be able to go back to continue. So he will not have the need to stay on whilst in the UK. But in terms of the application cost and everything, you are sponsoring. Okay.
Okay, all right, all right. Thank you.
Thank you.
Thank you very much. Thank you.
Great. So we have a few more questions, as you can see on screen. Hi, I'm a British citizen based in the UK. I went to Ghana for holidays and had a fling with a lady who got pregnant for me. My baby was born in May 2025. I want to apply for a British passport for him. How do I go about it? The birth certificate we have is the pink one. What documents do I need? And can I make the application in the UK?
Right. So the pink one, I don't know why it's the pink one, because if the child had just been born in May, the certificate wouldn't be pink one. I think the certificate would be the digital one. But either way, to be able to apply for overseas passport, there are a lot of things that we have to look at. Whether the lady was married when the child was born, whether you were married when the child was born. You said it was just a fling. So you and that lady are not married. So there will be a lot of conversations to go into as to whether to apply for right of abode for the child or to apply for passport for the child. Applying for passport for the child, they will look at whether indeed this is your child, whether at the time of pregnancy you were there, whether during the 9 months carrying of the baby you were going to visit all the time, evidence of the woman carrying the baby, the scans, all those things, including photos with the baby. And baby had just been born. I don't know how often you were to and fro Ghana, and so you need a range of things to be able to apply for passport for the child, if indeed this is your child. And so, yes, if you meet the requirement, you'll be able to apply for your child. However, I cannot say yes or no until I have tested what you have shared today.
Right. So we have another question from Sandra Fraser. Thank you, Sandra. If the victim has left the abuser for, let's say, 5 years, can they still use the events of the emotional abusers for their application?
So, 5 years. Where is the person now? Is the person in the UK? Has the person left the UK? How good, how well, or how bad is this person's condition? How good or bad is this person's situation or condition? I mean, 5 years, I'm sure the person is even better, has moved on. So if you've moved on, why cry for help? So there will be a lot of things to, even though it doesn't expire, why will you wait 5 years? Where are you now? Why do you want to come back? Why do you need help? How have you fared? So 5 years is a long, long delay. But hey, you never know.
Thank you, Sandra, for your question. So we have another question from Emilia. Any advice on holiday visa, please, Lawyer Charles?
Holiday visa to where?
Hmm.
To Venice or to Jupiter? We don't know. Any advice on holiday visa? We don't know which country. Every country has its own holiday visa requirement. If you are going to the US, I'm not sure whether you have a visa in the UK to apply to go to US. If you're in your country and you want to go to US, I don't know whether you meet the requirement. So it depends on which country and whether if you get a visa, you will return back to your country. So that the question is not conclusive enough.
Mm, yes. All right. I've been told that we have a follow-up question from Irene. So she says, please, when I was coming to the UK, I have a problem with them, so they cancelled it. So this is the lady who was talking about her passport being with the border force. Yeah. So she's
Okay.
now
Well,
explained.
okay. Is it so? The whatever I want. Okay. So, Irene, if you are going to your country and you don't have a visa in the UK, you know that you cannot return. But once you have decided to go back, because your purpose of coming to the UK has ended, for example, then you can ignore what they are holding, go and get travel certificate and go. When you go to your country, you are back home. You can apply for replacement passport. Otherwise, you have to chase.
All right. So
Um,
a
let me and
question.
let's add this. I'm sure Irene will say, "How do I chase?"
Hmm.
There is a switchboard for those who want to return home voluntarily. So voluntary return. So if you search voluntary UK Border Force voluntary return helpline, call them, tell them that you have my passport. I want to go back. Can you give me my passport so that I can go, or can you arrange for me to return home? They will do that.
Okay. So I saw a question from Daniel Opong. Hi, lawyer. Which application form can you use to apply for indefinite leave to remain under partner routes?
The parent or
Okay.
partner.
So that was his first question. What form to use?
Is this the first question?
This is the second question. So let's
No.
go back to the first question, producer. Yeah. So this is the first question, please.
Parent route, right? Or partner route?
Parent routes.
Parent. So parent route, you use set adult relative, because you are an adult relative of that child whom you depended or applied to stay for that long. So set adult relative. So set AR.
All right. Thank you. So on to the second question.
So for the second question, certificate, can you provide if you echo that? Yeah, so my second so marriage certificate is which marriage certificate can you provide when both of you are here in the UK as a partner and put in application? Are you married? If you are married, what certificate were you issued? I don't know. So if you are not married, you cannot just ask which certificate will I get when I marry. Go and marry first, and they will issue you with a certificate. If you want to marry in the UK, go to the council and speak to the council that you want to get married. Council will do the checks with the Home Office. Home Office may interview you or may go through the process. Once you are cleared by the Home Office, council will then give you a date to go through the marriage ceremonies with you. But all this should be with the council if you want to marry in the UK. If you want to marry in your country, then you have to check what the country's law say about those who want to marry whilst they are abroad.
That's very, very helpful. Thank you. So now just going back to the test your knowledge, um, I'm going to read the scenario again. So Agnes and Jude married in 2020 on the basis of Jude's status as an EU national resident in the UK and her marriage to Jude. Agnes was granted a 6-month visa to joined Jude in 2021. Upon arrival in the UK, she was granted a 5-year pre settled status. In September 2024, Agnes moved out of the family home to save her life due to domestic violence. In December 2024, she received a letter from the Home Office that her visa may be cancelled in 3 months because she ceased to be a family member of Jude. So we have a few options when it comes to advising Agnes. Number one, as Agnes left Jude, she cannot do anything about the notice to cancel her pre-settled status. That's number one. Or number two, Agnes should make a fresh application based on her retained rights as a spouse of Jude. Three, Agnes should respond to the notice citing domestic violence. Or four, Agnes should make a fresh application under a different visa category to avoid becoming an overstayer. So let's see what people think it is. So Millicent thinks the answer is three, that Agnes should respond to the notice. Buffer thinks that the answer is two, as in Agnes should make a fresh application based on her retained rights. Kwame says that the answer is three. Okay, let's see what else. Alberta says that the answer is four, as in Agnes should make a fresh application. This is very interesting. And Ifia says that the answer is number three. So, okay. And Frida lastly says that the answer is number three as well. So, Lawyer Charles, could you explain what the answer is and why that's the case, please?
Right. So let's go to the nugget. So under Annex 3, paragraph A3.4C of Appendix EU, a person who has 5 years leave to remain in the UK may have their leave curtailed if they cease to meet the requirement. What are the requirements? The requirements under Appendix EU, paragraph EU 14, which is 5 years pre-settled hold status, is that there should be a relationship to that EU national. If the person has ceased to have that relationship, then they have ceased to meet the requirement. So they will tell them that this is the decision to be made. That is to cancel your leave because you have ceased to be a family member of that EU national, and so you have ceased to meet the requirement. What is the best thing for the person to do if they want to prevent the visa from getting cancelled or curtailed? The first one, what it says that Agnes, what is the examiner saying to Agnes on the first point?
Agnes left Jude. She cannot do
No, no, no,
anything
no.
about the no
What? Oh, okay,
cancel
yeah,
her.
good.
Yeah.
Okay, okay. So the first one, it says that Agnes left Jude, so there's nothing he can do.
Mm,
But if there's nothing Agnes can do, then they wouldn't say we want to cancel. So she has to do something. So you can't say don't do anything. That would be really, really end of it for Agnes. So that would be a very, very bad advice. Then the next one is that Agnes should make fresh application. Why should Agnes make fresh application if there is reason to protect the existing visa? So Agnes should explore options first.
mm,
Three, Agnes should respond to the notice citing domestic violence. If Agnes is under domestic violence or is being a victim of domestic violence, and that has made the relationship to become bad or to go bad, then it's possible that they have separated. So Agnes is living somewhere, and the partner is living somewhere, and the partner might have potentially told the authorities that they are no longer living together, and on that basis, the authorities think that the relationship has ceased, and so Agnes has ceased to meet the requirement under paragraph A3.4C. Agnes will say that no, I haven't ceased. It's just me going through abuse and fleeing for my life. But the marriage is still there. We haven't divorced. And so I'm still a family member and I still meet the requirement under that paragraph. And on that basis, they will make a decision to reinstate if the reason is domestic violence or if the reason is that she's protecting herself as opposed to the fact that the relationship is broken down and so she's no longer a family member per se. Four says that Agnes should what? Make a
make
fresh
fresh
application under. So all fresh applications will not be great for Agnes.
mm.
And so Agnes should stick to her grounds, respond, citing the reasons, and she will succeed.
Okay, yes. So there you have it. The answer is number three. Agnes should respond to the notice, as Laura Charles said, explaining that she has not ceased to be a spouse of Jude. She left the family home due to domestic violence, and that she did so to save her life. Yeah, and this is in line with Annex 3, paragraph A3.4C of Appendix EU to the immigration rules. Yeah.
Loyani, before you progress, I think there is an emergency request on the platform, so I'm not sure
Okay.
whether you will grant amnesty for this person.
Yes, of course. Is it this one?
Yes. So it
Okay.
says, should I go ahead? Maybe you ask the person to go ahead.
Yes, go ahead with your question. Okay, let me read what he said so far. Good afternoon. I have a serious issue that I want to ask a question about. I'll be very happy if you can address it for me. Yeah. So, Akeem, if you could go ahead with your question. Okay, whilst we're waiting for Akeem, Sandra Fraser has asked a question. A friend just sent me the question, please, lawyer. An employee shouted at her manager for being a naga while she was serving clients um, camaraderie caught the employee being angry according to her body language. This manager has always been in employees' nerves and seen as a racist, but nobody has reported her, and this particular employee knows it, so she avoids her as much as she can. By the way, the manager is one of the many managers in the shop. She reported her and straight away was asked to go home. And after staying at home for 3 days, they sent an emergency email to attend a meeting after deliberation. She has been suspended. She needs answers. Lawyer Charles, please.
Okay,
What
so
can she
let's look
do?
at can you go back to so
Yes.
let's look at the reason. It says an employee shouted at her manager for being a naga. All right. Was the is a nigga, I suppose, while she was serving clients, called the employee being angry according to her body language. Anyway, this manager has always been at the employee's nerves and seen a racist. So, okay. By the way, the manager is one of the many. I'm trying to get the link. Um, staying at. So this employee has been suspended, right? So is this the employee who was abusing literally the manager?
It looks like.
Yeah. Okay. So let's assume that the employee's behavior was that of assaulting the manager by calling the manager nigger and all that. Oh, nagging.
Yes.
Right. Oh, okay. A nagger. Okay. All right. So, okay. So an employee should shatter the manager for being. So the employee was not happy that the manager nags. But how do you define nagging? If the person is always telling you do what you have to do, is that nagging? I'm not sure that is nagging.
Mm.
Because your interpretation of nagging may be different from the general interpretation of nagging. If we go to employment tribunal or ACAS to say that um, my manager was always nagging and I got upset and blah blah blah, and that has led to this. How do you define nagging? So what did this employee actually do? What is his behavior? He says, no, please. I think our friend who needs help will have to take time to approach because the information is not quite clear. So if we don't know her behavior. If her behavior has led to her suspension, then, but let's look at it holistically. How many years has this person worked for the restaurant or the employer? If 2 years plus, then the person will meet the requirement under Section 94 of the Employment Rights Act 1996, which says that an employee has a right not to be unfairly dismissed. If the person has been unfairly dismissed without going through the processes of warning, of training, of reprimanding, stage 1, stage 2, stage 3, and all those things, then will the dismissal be fair? But the person has been suspended, right? Not dismissed. Is the person 5 years? Okay, has the person suspended? Is it suspension or dismissal?
It looks like it's suspension.
Suspension for investigation. That's fair.
Mm,
Okay, so maybe they are investigating the matter. So that is the procedure. So the employer is right to suspend you while they look into the matter. But if the person is eventually dismissed after the suspension, then it might be unfair in all other circumstances. And so the case of Birchall and ACA's procedures may mean that there is unfair dismissal.
yeah. So, Sandra, please ask the person just to call the office so that we can advise them further. Charles, do you have anything else to say before we end the show today?
Thank you very much, Lawyer Annie. You've been a superb host. Pleasure
Thank you.
to be my host. Now, today's conversation was mainly about domestic violence applications. We've covered all the areas. We understood that those who come under Appendix FM, those who come under Appendix EU, those who come under skilled work can qualify under this provision if their dependent sponsor is abusing them financially, emotionally, or physically. We've touched on examples. You have to prove that that is the case. Now you'll be given 3 months by way of survival. And if you meet the settlement requirement, you'll be given settlement. However, those under work route may only be given concession 3 months and not indefinite. But indefinite is not automatic. And so before you apply for your indefinite, make sure that you have a lot of evidence to support your claim. Under domestic violence, you can apply for it anytime, even after your visa has expired. It is still possible, but you have to show that it happened and this is it. Again, if your application is refused, that is the end of life for you in terms of your status. And so there will be no right of appeal unless you seek judicial review to say that they did not consider your application fairly. And so you want to seek review. Otherwise, what we are saying is that make sure before you put in the application, you meet the requirement and you have enough evidence to support your claim so that you have good chance of success.
Thank you very much, Lawyer Charles, for today. I mean, we have all learned so much. And at this stage, I'd also like to thank our listeners and viewers for staying with us until the very end. I hope that you all have learned something and that even if today's topic doesn't necessarily apply to you, that you're able to share it with someone to help someone out within the community. So I've been your host for today. My name is Annie Akofiosowa. May God bless you all and keep you. Bye bye.